Why is it important for some clients to consider settling their case pre-indictment prior to the case going to a grand jury?
The plea bargaining practice in federal court is one that is driven by what we call relevant conduct, by the facts that are either presented to a jury or admitted by a defendant. And those facts drive the application of the United States sentencing guidelines, which are a formulaic approach to sentencing, and the United States Code section that applies to sentencing that a district court judge is mandated to follow. The United States Attorney's Office has a policy, and it's a Department of Justice policy, and it's across the country, that after the case goes to the grand jury and the grand jury returns an indictment, a prosecutor is to seek a guilty plea and an application of the sentencing rules to the most serious, readily provable offense in the indictment. Before the case goes to the grand jury, however, in a quid pro quo bargaining setting, it's possible to limit the charges that a defendant would have to enter a guilty plea to. It's much easier to limit the set of facts that will drive the application of the sentencing rules. And because of the early nature of the disposition, it is much easier to argue for a greatly reduced sentence. Now, knowing whether to pursue a pre-indictment resolution or forcing the government to take the case to the grand jury and possibly to trial, that's the trick. And that's where there can be no guesswork. That's where it's critical that you have a federal criminal defense attorney who can advise intelligently on that very important decision.